Alright folks, welcome back to the channel, and let me tell you, today's video is a 2-for-1 special of courtroom chaos that you absolutely do not want to miss. We're starting in Florida, where a man named Jason Walter is sitting in jail, charged with possession of a gallon of methamphetamine and a gram of fentanyl. Yes, you heard that right, a gallon of meth. And he's decided that his court-appointed attorney just isn't cutting it. So what does he do? He asks to represent himself. Now that might sound brave, maybe even a little admirable in a David versus Goliath kind of way, except for one small problem. Jason hasn't finished high school, has no GED, has never seen a criminal trial, doesn't know what the Florida evidence code is, and, this is the kicker, he believes a vast conspiracy involving the sheriff's department, the public defender's office, and something called gangstalking is being orchestrated specifically against him. The judge is going to walk him through what's called a Faretta inquiry, which is the legal process for determining whether someone is mentally and intellectually capable of representing themselves in court. And let me tell you, this one goes off the rails fast. But that's only the first half. After that, we're heading to Kansas, where a young man named Brady Smith is on probation for a felony and has apparently decided that probation requirements are more like probation suggestions. He hasn't reported to his probation officer, hasn't started his court-ordered treatment, and missed multiple court dates. So many that the judge issued a warrant for his arrest. Now he's appearing via Zoom from the side of a highway, claiming his wife can't see and he can't drive, while the judge tells him point blank, if you can't get a ride, start walking. 2 cases, 2 defendants who seem completely allergic to taking responsibility, and 2 judges who are absolutely not having it. Let's dive in.
Your Honor, this is Jason Walterman, 24 CF 1518. You asked to put him on towards the end of today's docket.
I just didn't want to do the Faretta hearing because it takes a while and leave everyone else waiting.
Yes, Your Honor.
All right, Mr. Walterman, what are you asking the court to do?
Dismiss these charges.
Well, that's not what we're here for. No, that's not going to happen. I don't get to dismiss charges unless a motion is filed.
Yes, I filed a motion to suppress and a motion to dismiss. I guess it's not reached again, the mail from the jail.
Y'all seen anything?
Second time I've submitted it.
Well,
Right.
the issue is, Mr. Walterman, is that you're represented by counsel. And so
Yes.
when you file things, when you're represented by counsel, unless they're adopted by your lawyer as motions they want to pursue, then they're a nullity. It's like they never happen. They get struck. So other than dismissing the case, what are you asking for?
You reviewed discovery, see it's been amended several times due to the unlawful traffic stop. Everything that's supposed or alleged evidence is inadmissible in court. The charges are completely fraudulent. I did not possess a gallon of methamphetamines nor a gram of fentanyl at all. It was a targeted.
Mr. Walterman,
Yes, sir.
earlier you said you wanted to talk to me about either representing yourself or getting a different lawyer. So that's what I brought you back to talk about.
Yes, sir. Yes, I asked counsel to put these motions in with the case law, and I did all the work and told her about it. She didn't submit it, so here I am. I guess I need to represent myself. I don't want to be another statistic.
Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
So help me God.
All right. Can you state your full name and date of birth?
Jason Michael Walterman, 79, 45 years old.
So right out of the gate, the judge is laying down a critical piece of legal procedure that Jason clearly doesn't understand. When you have a court-appointed attorney, you can't just file your own motions on the side like you're running a parallel legal operation. Any motions you want filed have to go through your attorney. And if your attorney doesn't believe those motions have merit, if they can't in good faith argue them before the court, then those motions aren't getting filed. That's not corruption. That's not your lawyer working against you. That's an ethical obligation that every attorney in this country is bound by. Lawyers can face disciplinary action, even disbarment, for filing frivolous motions. So when Jason says he did all the work and his attorney refused to file it, what he's really telling us is that a trained legal professional reviewed his arguments and determined they had no legitimate basis. But Jason doesn't see it that way. To him, this is proof that the system is rigged, and that mindset is about to take us down a very interesting path.
Mr. Walterman, do you understand that lawyers have an ethical obligation not to pursue motions that they don't think that they can't in good faith think they're going to win? You understand that?
I realize that it's working against me, that's for sure.
That's not what my question was. My question is, do you understand if you ask your attorney to file a motion that he or she says, I don't think I've got a good faith basis to file, they're not going to file one because it would be unethical for them to do so?
I guess that's why we're here today,
Okay.
needing to relieve
But
my counsel.
again, my question is, do you understand that?
Do I understand that it's, that she didn't want to put the motion in for me?
I asked you a question. I asked if you understood it. That usually involves a yes or no answer.
Yes.
Okay, so you do understand that. So you've asked to file, or you've actually filed your own motions, but since you're represented, they're a nullity. Okay?
I must submit those?
Unless you're representing yourself. But I have to go through what's called a Faretta inquiry to find out if I think you're able to represent yourself. So, again, what are you asking for today?
I would like to represent myself. Do not
Why?
believe that the council has my best interest at heart, or
All right, so the issue, do you want to represent yourself, or you just have an issue with your current counsel?
you know, I realize the state's attorney's office is running the whole program between the sheriff's department, the public defender's office, even the outreach or conflict counsel, and you know, as much corruption as I've seen them operating at, I don't feel safe with any of them handling my life. Manufacturing charges, tampering with evidence, falsifying police reports and certified documentation, targeting individuals, me especially, defamating my character publicly, personally.
Why do you think you're being targeted?
That I have not figured out yet. Stuck with no resources, you know, I don't have any law library, real.
Yeah, but you understand that you're currently in jail because you failed to appear for your
Yes, sir.
trial date.
I sure did.
All right, so are you trying to represent yourself?
Yes, sir.
That's what you want, okay. How far have you gone in school, Mr. Walterman?
Almost the 12th grade.
If I asked to verify information, I'm not trying to be offensive or anything like that, Mr. Walterman, but what you said was you didn't finish high school.
No, sir.
Did you get your GED?
No, sir.
And do you have a career field?
Professional construction worker, supervisor,
Let's pause here for a second and really take in what just happened. The judge asked Jason a simple, direct question. Why do you think you're being targeted? And Jason's answer was, and I quote, I have not figured out yet. Think about that. He is absolutely 100% certain that there is a massive coordinated conspiracy involving the state attorney's office, the sheriff's department, the public defender's office, and even conflict counsel, all working together to frame him. But he has no idea why. He can't name a motive. He can't identify who specifically is orchestrating this. He just knows it's happening. Now, the narrator already filled in the blanks for us. The police targeted him because he allegedly had a gallon of methamphetamine and fentanyl, and stopping drug distribution is literally their job. But here's the thing that really concerns the judge, and we'll see this play out shortly. These aren't just the complaints of someone unhappy with their legal representation. These are the kinds of statements that raise serious red flags about whether this person is mentally competent to stand trial. Keep that in mind as this hearing progresses, because the judge is clearly already thinking about it.
superintendent.
Okay. And when's the last time that you've worked?
6 months ago, something like that. I've been in jail for about 5 months now.
Okay.
This has cost me 2 jobs already, my vehicle, my place to stay
That's-
twice.
I'd appreciate if you would just stay on track with what I'm asking you, Mr. Walterman.
Yes, sir.
Have you ever represented yourself before?
No, sir. Not in a court of law.
Okay, even in a traffic ticket or anything like that?
I don't believe I've been to no traffic court.
Okay. Do you understand that you have a right to a lawyer?
Yes, sir.
And you understand that one has been appointed to you already?
Yes, sir.
But due to your concerns about what you said with the corruption, you'd like to represent yourself, is that right?
Yes, sir.
Even though the state of Florida pays for the lawyer for you?
Yes, sir.
Okay. And do you understand the advantages of having a lawyer?
No, sir.
Okay. So, say again?
I said, no, sir, I haven't received any advantages.
Okay. So a lawyer's legal knowledge and experience may favorably affect things like bail and pretrial release possibilities, may result in obtaining information about the case through skillful use of discovery devices, may uncover potential violations of constitutional rights, and take effective measures to address them, may ensure compliance with speedy trial and statute of limitations provisions, and may identify and secure favorable evidence to be introduced later at trial on your behalf. Do you understand all those things?
Yes, sir.
Okay, but you don't want to have a lawyer do that for you?
Constitutional civil rights have been violated to a serious degree already. I think I got my best interest at heart. If I had the law resources, I could skillfully and professionally present the actual facts of the case, and that should be enough to abolish my charges and set me free.
Mr. Walterman, I'm looking at the discovery exhibits because you said they've added a bunch of officers.
No,
Hold on. From my reading of it, the only one they added on the amended discovery exhibit was a Deputy Langer. Everyone else was already listed, and if you read on the actual exhibit, it says, this amended discovery adds previously unlisted Deputy Sheriff Langer and recategorizes the deputy sheriffs who were previously disclosed in initial discovery dated 8/6/24. So it only added one person. It just recategorized people as they need to be under Florida Rule of Procedure 3.220. The second amended discovery added an FDLE chemist, who I'm assuming tested the substances to determine what they were. So there's only one new law enforcement officer that was added, and you made it sound like there was 12 to 15.
I'm asking where's their accounts of being on that scene.
Okay, so let's do a quick reality check here, because the picture the judge is painting through these Faretta inquiry questions is absolutely devastating. Jason Walter did not finish high school, no GED, has never represented himself in any legal proceeding, not even a traffic ticket, doesn't know what the Florida evidence code is, has never seen a criminal trial, has never watched jury selection, and is currently sitting in jail because he failed to appear for his own trial date. And yet, with perfect confidence, he says, and I'm paraphrasing here, if I had the resources, I could skillfully and professionally present the facts and get myself set free. Skillfully and professionally. Those are his words. This man is facing felony drug charges that carry serious prison time, and he genuinely believes that he, with no legal education, no courtroom experience, and no understanding of evidence rules, can do a better job than a trained attorney. Now here's a question for all of you watching. Do you think the judge should let him represent himself? Or is this one of those cases where the court needs to step in and protect someone from their own worst instincts? Drop your thoughts in the comments.
It only shows those few officers where there was a whole lot more. Like I said, before I could put the gear shifter in park, there was a splash of a targeted, coordinated event, not an everyday ordinary traffic stop as my counsel told me it was. My tag light was not out of place, nor was the tag. It was right on the bumper.
I'm not asking you anything about the facts of the case, sir. Mr. Walterman, have you ever seen a criminal trial? Have you ever seen jury selection?
No, sir.
You think it might be an advantage to have a lawyer who's participated in trials and jury selection to aid you through this process?
I couldn't afford an attorney that was in my interest.
You understand that at a trial you have the right to remain silent?
Yes, sir.
And do you understand at a trial you have a right to testify and tell your side of it?
Yes, sir.
Do you think it might be an advantage to have a lawyer to counsel you on as to which one would be better for you and give you the pros and cons of those things?
Yes, sir.
Okay.
Had a lawyer, but I didn't receive any sureties or counsel of upholding nature.
I'm not sure what you're saying. You're going to just be a little louder, Mr.
I
Walter.
wasn't presented with any factual knowledge or, how to guide this case with counsel, other than she wanted me to commit perjury and be extorted for $1,000 to accept 2 felony drug charges that I didn't possess any drugs for to begin with.
She wanted you to commit perjury and be extorted.
Well, that's what admitting to guilt, would have been committing a crime to say I'm guilty. That is perjury.
Well, Mr. Walterman, most people who enter a plea in my courtroom end up pleading no contest, which means they're not admitting their guilt, and they're doing so because it's in their best interest. Not admitting their guilt at all.
But I am not guilty.
I understand. I'm just... Do you understand that a lawyer can call witnesses for you and make sure they come to court? I need an answer, Mr.
Yes,
Walter.
sir.
Okay. The microphone doesn't pick up nodding.
Yes, sir.
Do you feel that you could question witnesses who appear against you?
Yes, sir.
Okay. Have you ever cross-examined a witness before?
No, sir.
So based on my earlier questions about knowing the evidence code, wouldn't it be helpful to have someone who is familiar with the evidence code question the witnesses?
Would most certainly be helpful.
Okay. But you don't want that advantage?
Yes, just counsel would be just fine with me. I was stating I haven't received that.
Okay. But again, I've asked you if you had an issue with your lawyer, and you said you just want to represent yourself.
Well, my best interest wasn't being looked out for. That's why I was needing to.
How so?
I did the work, studied the case law that backed up the findings for my plea of not guilty for every account with extra backup on it. Gave her the motions or told her
Case
which
law
motion.
for your plea of not guilty?
Well, that was backing up the case that I'm fighting right now for my freedom, and the charges that was put against me, stating what made those charges not of any merit or substance, and I wasn't.
All right, so the judge just did something really important here that I want to highlight. He actually pulled up the discovery exhibits in real time and fact-checked Jason's claims on the spot. Jason made it sound like the prosecution was secretly adding dozens of officers to the discovery to manufacture evidence against him. The reality? They added one officer, Deputy Langanger, who was on scene but hadn't been initially listed, and they recategorized the other officers to comply with Florida Rule of Criminal Procedure 3.220. The Second Amendment added an FDLE chemist, which is completely standard. Someone from the crime lab tested the substances, and now they need to be listed as a potential witness. That's it. That's the big conspiracy. One additional officer and a lab technician. Discovery gets amended in virtually every criminal case as the investigation develops, and the judge, who was both a prosecutor and a defense lawyer before taking the bench, confirms this is entirely routine. But Jason sees every procedural step as further proof that the system is out to get him. This is what makes representing yourself so dangerous. When you don't understand the process, normal procedure looks like corruption.
Getting nothing but this is the best I can do. Plead guilty to something you're not guilty of. Okay, to target individuals in Florida to do this type of extortion or bullying or gang stalking, or
Who's gang stalking? What does that mean?
it's where a group of individuals conjure or coordinate coincidence to attack a being, to take advantage of it.
You're saying someone's doing that to you? Time based on what I've heard, Mr. Walterman, I can't find that you're capable of representing yourselves in this case. In fact, I think an evaluation might be in order. 'Cause I'm not sure you understand what's going on here.
I certainly understand what's going on.
Well, based on my readings of what you've written in your pleadings and your answers to my questions today and your allegations of gang stalking and corruption against you, but you've given no reason why that would happen or even really who's doing it, I've got concerns as to whether or not you can really handle this case on your own, number one, and whether or not you're even capable of entering a plea or going to trial.
So can you appoint me some just counsel? So, that's going to be
I
fair
have.
within the law.
You haven't told me anything that's wrong with your counsel. Other than just to say this kind of conclusory statement that they're unjust.
I'm not guilty of the charges, yet I was asked to plead guilty to 2 felony drug counts that I didn't
Were you
possess.
asked to plead plead guilty, or were you told what your plea offer was?
Just that was the best that she could do.
Okay, and sometimes the best that can be done
Break
is
the
not.
law and pay them $1,000 to just walk away.
Again, I just don't really think you understand how this process works, and your lawyer's trying to explain that to you. And at this point, I'm finding under a Faretta inquiry that you're not capable of representing yourself.
Okay.
Ms. Rivers?
Your Honor, the issue remains that he refuses to get the evaluation. I've tried twice for the evaluation. He refuses to get the evaluation.
Is that the one you tried to do internally?
Yes, Your Honor.
All right, then I'd like an order appointing
Yes, Your Honor.
a doctor to do that evaluation. And Mr. Walterman, I'm going to order you to take that evaluation. And if you refuse to do so, you'll be held until you agree to do it. Because it's concerning that you're refusing to follow your attorney's advice in doing this. And now, from what I've heard, I've got the same concerns that you may not be competent to proceed. Anything else, Mr. Walterman?
Sir?
All right, I'm going to put it on October 29th at 9. I would like that order so I can sign it certainly this week, Ms. Rivers, and then they'll send someone out to talk to you at the jail.
All right.
It may be done by Zoom.
What about new counsel?
Again, you haven't told me anything other than a conclusory statement that she's unjust. So I'm not going to remove her from your case and add someone else until you show me that she's done something wrong.
Kind of hard to show you any evidence. Stuck at the county jail. I talked to her. They come and stole all my paperwork, destroyed all the stuff, my property, immediately after I talked to her the first time. And I finally got a rediscovery, and it showed that it's been re-amended after I spoke with her again and was telling her some of the facts of the case that would be presenting my innocence.
Discovery is amended all the time, Mr. Walterman.
Yes, that's right.
As they add an officer who they didn't initially know about, or adding someone who's new as far as an analyst who's looked at substances, or like the chemist that was added in your case. Those people weren't witnesses until they became witnesses during the case, into the course of the case. I can tell you, as I was a prosecutor and a defense lawyer before I took the bench. I've had cases where we've had 15 to 20 amended discovery exhibits, depending on what the case is. It's just part of the process.
What about a fair and just due process? We were supposed to go to a trial a long time ago, and they keep putting it off.
You've missed court twice and been failed to appear twice. That's why you haven't had a speedy trial. And you didn't appear for your docket day.
And there it is, folks, the moment this entire hearing has been building toward. The judge has heard enough. After walking Jason through every single aspect of the Faretta inquiry, his education, his legal knowledge, his understanding of courtroom procedure, his experience with trials, his grasp of the evidence code, the judge has determined that Jason Walter is not capable of representing himself. And honestly, this might be the best thing that could have happened to him today, even if he doesn't realize it. But it doesn't stop there. The judge goes one step further and says an evaluation might be in order. And he's talking about a competency evaluation. That's not just the court saying you're not smart enough to be your own lawyer. That's the court raising a genuine concern about whether this defendant understands the nature of the proceedings against him at all. The allegations of gangstalking, the belief that every branch of the justice system is conspiring against him personally, the inability to articulate why anyone would target him, these are the kinds of statements that trigger competency concerns. And under Florida law, if a judge has reasonable grounds to believe a defendant may be incompetent to proceed, they are required to order an evaluation. This is the court doing its job to protect a defendant's rights, even when that defendant doesn't want the protection.
And because of that, I issued a warrant for your arrest because you didn't show up. And that's why you're sitting in jail, because you're a flight risk at this point after 2 times missing court and have to be rearrested. Anything else, Mr. Walterman?
No, sir.
All right, thank you. October 29th, 9 o'clock.
All right, we'll go on the record in State of Kansas versus Brady Smith, case number 24 CR 101. Would counsel announce appearances, please?
May it please the court, the state appears by Joe Gillette, County Attorney.
William McClendon for the defendant, Brady Smith, who appears via Zoom from a separate location.
And also appearing is Ed Ketley with Community Corrections, who is Mr. Smith's ISO. We're scheduled today for hearing on a warrant to show cause. Announcements, Mr. McClendon.
Yes, Judge, we'd be stipulating to a probation violation.
All right,
on this.
Mr. Smith, you wish to waive evidentiary hearing and stipulate to the violations?
Yes, Your Honor.
Do you understand that you are entitled to have a hearing? At that hearing, the state would be required to prove by a preponderance of the evidence that you did in fact violate your probation as alleged in the warrant to show cause?
Yes, Your Honor.
You understand that by waiving your right to hearing and stipulating to the violations that the court will find that you violated your probation?
Yes, Your Honor.
And do you understand that you could be looking at serving some sort of a jail sanction, that your probation could be extended, or in some situations your probation could be revoked and you could be ordered to serve the balance of your sentence?
Yes, Your Honor.
All right, I will find, Mr. Smith, that you've made a knowing and voluntary waiver of hearing and have stipulated to the violations as alleged in the warrant to show cause. Based on the stipulation, the court will find that you've violated your probation. Is there any sort of an agreed upon disposition, counsel?
Judge,
Yes, Judge. Go ahead. Sorry.
I'm recommending, this is his first revocation, and it is a Senate Bill 123 case. I don't know, and Mr. Ketley will have to tell us if Cali County will even try to take him back. But he needs to have a sanction. I'm going to ask for a 3-day quick dip. And then he will need to meet with Mr. Ketley as soon as he is released. He was supposed to be at the courthouse today so that he could start his quick dip today. So he's going to have to get himself turned in on his quick dip. I'd like that to be a condition of probation and of his community corrections. If he does not get himself turned in for his quick dip, then I would like authorization for Mr. Ketley to issue a warrant.
Mr. McClendon, your recommendations?
Judge, that'd be our recommendations as well. We just ask that he have till 5 p.m. tomorrow to turn himself in.
Mr. Ketley, any information you wish to provide?
No, Your Honor.
So he's being supervised in Cali County?
No, Your Honor, they tried to contact him. He never responded to them. So he's been kind of in limbo ever since.
All right, and he hasn't been reporting to you?
That's correct.
Okay, and he hasn't started Senate bill treatment?
I believe that's correct.
All right, Mr. Smith, anything you'd like to say?
No, Your Honor.
How come you're not reporting?
My driver, so my wife has been having problems with her left eye, and she went into the eye doctor yesterday, and they did some sort of like pressure test, and most people have like 0% pressure on their eyes.
I don't need to know all the details. So since January, you haven't been able to report or call in?
Well, I was say I talked to Ed initially after we got sentenced and whatnot, and then we were waiting for Cali County to get a hold of the paperwork and all that, and then
Did you
like I was
contact
telling
Cali County to find out what the?
What a hearing. Let's quickly recap DGK before we move on to our second case. Jason Walter came into that courtroom wanting two things: to fire his lawyer and represent himself. He walked away with neither. The judge denied his request to represent himself under the Faretta standard, kept his current attorney on the case, and here's the part that Jason definitely didn't see coming: ordered a mandatory competency evaluation. That means a doctor EGK you going to be sent to the jail. GGK even understands the legal price against him well enough to stand trial. If he's found incompetent, the case gets paused until he receives treatment and is deemed competent to proceed. And the cherry on top? The judge pointed out that the reason Jason hasn't had a speedy trial isn't because of some grand conspiracy, it's because he failed to appear in court twice and had to be rearrested. He's literally the reason for his own delays. Now let's shift gears entirely and head to Kansas K, where our next defendant has a completely different set of problems, but an eerily similar attitude toward personal responsibility. This one's going to be quick, but it packs a punch.
Status of the paperwork was?
well, so I got into a rollover accident and I was in the hospital for like a month, and that's when Cali County had called me, and when I got out, they had already issued a warrant.
How come you haven't started treatment?
I'm currently waiting on a bed date right now.
What, for where?
Huh?
Where?
At PFH.
Where's that?
It's in Winfield.
Where are you physically located right now?
I'm on the side of the highway, like 40 minutes away from Eureka.
All right, you need to check in by 12:30 today and serve 3 days in jail.
I don't have, that's my problem right now, Your Honor, is I don't have like any way to move at the moment. I don't have a driver's license, and my wife can't see at the moment, and so I've been trying to find a ride since like 8:30 this morning.
So you and your wife are sitting in a car on the side of the road and she's unable to drive?
Yeah, like I was saying, her vision in her left eye has been completely gone. I was saying, she's sitting right here next to me. I mean, she went to the eye doctor yesterday, and they're trying to get it figured out, and it was like just blurry, and it would kind of come back, but she said that she can't see
Have
anything
you
out of
made
her left
contact with
eye.
anybody to come get you?
That my mom is the only one, and she's just under 2 hours away from me, and I'm still waiting for her to tell me if she can come or not. Other than that, I don't really have anybody to come get me, because like her mom and sister and everybody are all at work until 5 p.m. And like I said, I'm just waiting on my mom at the moment to see if she can even come get us.
To report to the Greenwood County Jail by 5 o'clock today.
Did you say can I, or I?
No, I said you've been ordered to report there by 5 o'clock p.m. today.
Okay.
If you need to start walking, start walking.
Alrighty.
You need to start taking your probation seriously. You're lucky you're only getting 3 days.
I know, Your Honor.
So you're to report by 5 o'clock PM today to the Greenwood County Jail in Eureka to serve 3 days as a sanction. Then you'll need to be back reporting. Mr. Catley, have you provided him with reporting instructions, or do you need to do that?
I have not yet, Your Honor. I haven't spoken with him.
Does
Brady,
he-
you just need to call me on Monday when you get out of jail, and we'll set up something.
Okay.
If
I'll get
you're
out on
not-
Sunday,
you're
and so
not-
just call you first thing Monday
Mr.
morning.
Smith,
Call me.
I'm trying to talk.
That's my fault. Call me Monday. That's correct.
If you don't report by 5 o'clock PM to the Greenwood County Jail, I'm going to order that you be held until we can get you back in front of the court.
Okay, Your Honor.
Understood? So if you can't get a ride, you need to start walking.
Okay.
It's a nice day. Are you working?
No, not at the moment.
Okay, why aren't you working?
Because I've had a lot of trouble trying to get a job, because everybody that I try and get a job for, they'll pull my criminal history, and it's really
Well,
Like,
I know
I've
plenty of
had
people.
interviews at Spirit. I've had interviews at Creekstone. I've had interviews at like 2 or 3 more places, and every time go in for it and whatnot, and then because of my
I
criminal
don't
history.
want to hear any more excuses.
Judge, I also need to have a determination as to whether or not there is any bids, application, or attorney's fees.
I know, Ms. Gillette, that's why I'm inquiring about his employment. I'm gonna order that you pay $250 towards Mr. McClendon's attorney's fees for today's hearing.
Okay, Your Honor.
What's your controlling sentence in this case?
20.
20. All right, I hope this is a wake-up call for you, Mr. Smith, because you've got 20 months in prison hanging over your head. If you don't start taking probation seriously, I'm just going to put you in prison.
Okay, Your Honor. I understand.
And by not checking in by 5 o'clock PM today would be one of the first steps.
Okay, I need everyone to fully absorb this situation because it is wild. Brady Smith is appearing for his probation violation hearing via Zoom from the side of a highway, 40 minutes away from where he needs to be. He doesn't have a driver's license. His wife, who was apparently his only driver, supposedly can't see out of her eye. He has no other ride except his mother, who lives 2 hours away. He was supposed to be at the courthouse in person today to start serving his 3-day jail sanction, but instead he's sitting in a car on the shoulder of some Kansas highway. And now the judge, who has clearly lost all patience, is about to tell him that he needs to check into the Greenwood County Jail by 5 PM today. And if he can't get a ride, he should start walking. Now, I want you to think about the bigger picture here. Brady was given probation instead of prison. That's a gift. All he had to do was check in with his probation officer, start treatment, and not get into trouble. He did none of those things. He didn't report, didn't start treatment, didn't respond when Cali County tried to contact him, and missed multiple court dates. The system gave him every possible chance, and he squandered all of them.
Towards a 20-month stay.
Okay, Your Honor.
All right, Ms. Gillette, anything else we need to do today with Mr. Smith's case?
Nope, I think that's all I needed from you. Thank you.
And Mr. McClendon?
No, Your Honor.
All right, Mr. Smith, make sure you call Mr. Ketley when you get out of jail, assuming you get checked in and serve your 3-day dip.
Okay, I can do that, Your Honor.
All right, if there's nothing further, we'll be in recess. Have a good day.
All right, folks, let's wrap up both of these cases with a professional overview because there are some genuinely important lessons here. In our first case, Jason Walter from Florida was facing felony drug charges, possession of a gallon of methamphetamine and a gram of fentanyl. He came before the judge requesting to represent himself after becoming dissatisfied with his court-appointed attorney, who refused to file motions that she determined lacked legal merit. The judge conducted a thorough Faretta inquiry, which is the constitutional standard established by the Supreme Court in Faretta versus California to determine whether a defendant can knowingly and intelligently waive their right to counsel. Throughout that inquiry, it became clear that Jason had no high school diploma, no GED, no legal training, no courtroom experience, no knowledge of the Florida Evidence Code, and had never even witnessed a trial. On top of that, his claims of systemic gang stalking and coordinated corruption, without being able to identify who was targeting him or why, raised serious concerns about his competency. The judge made two rulings. First, he denied the request for self-representation, and second, he ordered a competency evaluation under Florida statute. Jason's current attorney remains on the case, and the matter is continued to October 29th pending the results of that evaluation. In our second case, Brady Smith from Kansas was on felony probation under Senate Bill 123, which provides drug offenders with treatment as an alternative to prison. Instead of taking advantage of this opportunity, Brady failed to report to his probation officer, never started his court-ordered treatment, failed to respond to Cali County's attempts to contact him, and missed multiple court appearances, resulting in warrants for his arrest. He stipulated to the probation violation, and both the prosecution and defense agreed on a 3-day jail sanction as a first-time consequence. The judge ordered him to report to the Greenwood County Jail by 5 p.m. that day, with the explicit warning that failure to do so would result in being held until his next court appearance, and that continued noncompliance would lead to revocation of probation and a 20-month prison sentence. He was also ordered to pay $250 in attorney's fees. The common thread in both cases is a fundamental unwillingness to engage with the legal system in good faith. Jason believes the entire system is conspiring against him, so he refuses to cooperate with the one person, his attorney, who is actually trying to help him. Brady was given the extraordinary opportunity to avoid prison through treatment and supervision, and he treated every requirement as optional. Both judges handled these situations with remarkable patience and clarity, explaining at every step what the law requires and what consequences await. If you found these cases as eye-opening as we did, make sure to smash that like button, drop your thoughts in the comments. I especially want to know, do you think Jason's competency evaluation was the right call, or should the judge have let him try to represent himself? And do you think Brady is actually going to make it to that jail by 5 o'clock? Share this video with anyone who needs a reminder that the legal system is not something you can just ignore. And most importantly, subscribe to the channel and hit that notification bell so you never miss another jaw-dropping courtroom breakdown. We'll see you in the next one.